Hello and welcome to the Analyst dated 23rd October 2023 by Vajiram and Ravi, wherein we'll be looking into important current affairs article from both The Hindu as well as Indian Express. And the handout of this very discussion is available in the description below for your reference. Let's have a look over the table of content. So firstly, we'll be looking into judicial pendency. We'll try to understand that why we are witnessing judicial pendency in India, and what all steps the government of India has taken and what more needs to be done. Then we'll try to understand this concept called constitutional morality. We'll look into the relevant case laws, and we'll try to understand what is the significance and the issues pertaining to constitutional morality. Then we'll be looking into South China Sea dispute. We'll try to understand what is this dispute all about and the related terms related to this very dispute. Then we'll be looking into global wealth tax. Herein we'll be looking into prominent facts which could be asked in the prelims, like what is greenwashing, what is wealth tax, what is tax evasion, etc. And lastly, we'll be looking into the locational aspects with regard to Siachen Glacier because it is in news currently. Let's look into our first topic, which is related to judicial pendency. And this topic pertains to this very aspect of your GS paper 2 syllabus. Now, what is the context? So, the context is the Supreme Court has highlighted recently that there is an urgent need to take proactive steps in order to clear the huge backlog of cases which the Indian judiciary is witnessing currently. And in this regard, the Supreme Court has given the direction that the respective state chief justices have to form a committee which would be monitoring on a regular basis the cases which are pending for more than 5 years. Now, the first thing that we need to understand with regard to this article is what is judicial pendency? So, it basically refers to the clogged state of judicial system wherein the number of cases which are being filed is increasing at an exponentially high rate. At the other end, the number of cases which are being disposed of, on which the judgments have been given by the courts, it is at a very slow pace. So, on account of this, we are witnessing judicial backlog. When we talk about the data, so according to Ministry of Law and Justice, it has informed recently to the Rajya Sabha that there are over 5.02 crore cases which are pending in various courts in India. And when it comes to average pendency of cases, the highest average pendency is in case of UP, wherein the cases are pending for an average of 11.34 years, and the lowest is in case of Tripura, that is 1 year. Now, in this regard, we need to understand that what are the major causes on account of which we are witnessing huge backlog of cases in the Indian judiciary. First is, we are having very low judge to population ratio. In India, currently we have 21 judges per million population. However, in this regard, the Law Commission has recommended that there should be around 50 judge to per million population. Okay, the ratio should be 50 per million population. And in China, you have 159 judges per million population. So, this is one of the major reasons why we are witnessing judicial pendency, because the judges are low. So, the case clearance ratio is also quite low. What is case clearance ratio? It is basically the ratio of how many cases were instituted in a particular year and how many cases were disposed of in that particular year. So, as the judges are low, so the case clearance ratio is also low. This leads to judicial pendency. Then there is delay in filling of vacancies on account of disagreement between the center and the judiciary with regard to judicial appointments, and there is also disagreement with regard to memorandum of procedure which relates to appointment of judges to the Supreme Court and High Court. And in this regard, India Justice Report 2022 has highlighted that as of December 2022, High Courts are functioning with merely 778 judges against the sanctioned strength of 1,108 judges. This is another cause of judicial pendency. Then, what we have witnessed, and the data points out, that the government is the largest litigant. It is litigant in 46% of the total pending cases. This is another reason of high backlog of cases. Then frequent adjournment, which is prominently known as adjournment culture. Going by the rules, maximum of 3 adjournments are allowed per case. But what we are witnessing is this rule is not followed in over 50% of the cases, which we refer to as adjournment culture. This is another prominent reason of judicial pendency in India. Then delayed investigation. There are issues also in our criminal justice system, as was pointed out recently by the Supreme Court in Rajesh versus State of Madhya Pradesh case. In that, the Supreme Court highlighted that we need to come up with a standardized code of investigation. And in this regard, we need to train our police forces with regard to the latest forensic technology. And in this regard, the Supreme Court also made reference to these three, that is Justice Malimat Committee, Law Commission 239th report, and the Supreme Court's verdict in Prakash Singh versus Union of India 2006. In all these three, it was pointed out that we need to separate the law and order and investigation function of the police, so that a separate wing of police could focus on the investigation aspect and we could improve the investigation procedure as well. Then, on account of inadequate technological infrastructure when it comes to judiciary, this is on account of low allocation to the judicial infrastructure, which is around 0.08% to 0.09% of the GDP. When it comes to the adoption of technological infrastructure, it is quite slow when it comes to the judiciary. And see, technology could be used in form of judge analytics. What do I mean by judge analytics? So we can train an AI based software with the historical cases, okay, the precedents in the previous cases. And once this AI software gets trained, it would enable a judge to take effective decisions. How come? Because this software would provide the key relevant facts with regard to a particular case. And we can also use artificial intelligence based software to look into the cases which pertains to petty offences like violation of traffic rules, etc. But when it comes to the technological infrastructure in the judiciary, it is quite inadequate. Then the alternate dispute resolution mechanism is also ineffective. What do I mean by alternate dispute resolution mechanism? So it basically refers to settlement of dispute without a trial. So there are multiple, mechanisms of alternate dispute resolution. First is arbitration. So in arbitration, the two parties would be going to a neutral arbitrator, okay, and this arbitrator would be giving a binding decision, okay. So whatever decision the arbitrator would be making, that would be binding on the two parties. Then we have conciliation. So in conciliation, it is a non-binding procedure. So again, the parties would be going to a neutral third person, that is a conciliator, and that conciliator would enable the two parties to come at a mutually agreed settlement. Or we can go for negotiation. Again, this negotiation is a non-binding procedure wherein there is no involvement of any third party, neutral party. Rather, the two parties to the dispute, they start the discussions and negotiation in order to arrive at a negotiated settlement. But what we witness in case of India, that this ADR mechanism is not effective. Why? Firstly, people are not aware of these ADR mechanisms. Then we do not have much faith when it comes to the effectiveness of ADR mechanism, and there are very low ADR centers as well in India. And there is lack of, the skilled professionals which are needed in the ADR mechanism, like arbitrators, conciliator, mediators, etc. Now, let's look into the steps that the Government of India has taken in order to address this issue of judicial pendency. Now, the first is Memorandum of Procedure, which intends to ensure transparency when it comes to judicial appointments. However, the discussions between the central government and the judiciary are still continuing when it comes to the finalization of Memorandum of Procedure when it comes to judicial appointments. Let's look into the different aspects which are there with regard to this Memorandum of Procedure. So, whenever the collegium is elevating a High Court judge to the Supreme Court, it's need to look into the aspect of seniority. So it would be giving preference to a senior High Court judge as compared to a junior High Court judge when it comes to elevation from High Court to Supreme Court. Then, if the collegium is overlooking a senior most High Court judge when it comes to elevation from High Court to Supreme Court, and it is giving preference to a junior judge, then in that regard, the collegium has to give the reasons in writing that why it is doing so, why it is overlooking a senior most High Court judge. Then it talks about setting up a committee which would enable the collegium to evaluate the prospects of a candidate, okay, that whether the judge is suitable to be elevated to the Supreme Court or not from the High Court. Then it talks about creation of a secretariat which would be basically maintaining the database with regard to the High Court judges, and it would also be receiving the complaints and recommendations with regard to the judicial appointments. Last aspect is national interest and security of the state. So, the government has pointed out that the government should have the power to reject an appointment in the larger public interest and in the interest of national security. Now, when it comes to memorandum of procedure, the contentious aspects are that the collegium has to give the reasons in writing why it is overlooking a senior most High Court judge. In this regard, the judiciary has pointed out that if we give the reasons in writing, this would make the future prospects of such a High Court judge very bleak. So in future, that High Court judge might not be elevated to become a Supreme Court judge. And another contentious aspect is that the government is asking for the power to reject the appointments in the larger public interest and in the interest of national security. In this regard, the judiciary has pointed out that if we allow the government to do so, then it might prevent genuine, appointments of the judges. This is the reason that the discussions with regard to memorandum of procedure are still continuing, and the memorandum of procedure has yet not been finalized. But it is a major step when it comes to addressing the issue of low judge to population ratio, and it would even go a long way when it comes to addressing the issue of delay in filing of vacancies. Then there is Project Sahyog, which is a web-based portal which would be connecting the student researchers with the lawyers and the organizations which are providing pro bono legal services. What are pro bono legal services? That is, they provide free legal services and advice to the people who are unable to get legal aid. So this would go a long way in ensuring access to justice. Then there is LIMS, that is Legal Information Management and Briefing System, which would be ensuring effective management of the cases which pertains to central government. Then Mediation Bill 2023, it seeks to promote alternative dispute resolution mechanism, because mediation is also one of the alternative dispute resolution mechanism, wherein a neutral third party, that is a mediator, enable the two parties to arrive at a mutually agreed settlement. This mediation bill is promoting settlement of civil and commercial disputes before going to the court or before going to any of the tribunal by using the mediation mechanism. And it is also promoting online mediation so that the cost of litigation could go down to a great extent. Then we have this e-court mission, which is giving boost to the digital infrastructure in the judiciary. So under this we have virtual justice clocks, which provides us with the vital statistics with regard to the number of cases instituted, number of cases disposed of, and how many cases are still pending. This data is provided to us on a weekly, on a daily and on a monthly basis. Then there are virtual courts, which basically looks into the issues which pertains to violation of traffic rules, challans, etc. E-filing of legal documents is being done. e-payments of court fees and fines which are levied against a particular person. In that regard, e-payments web portal is there. Then we have National Litigation Policy 2010, which is going to make sure that the government act as a efficient and responsible litigant. So the government would not be filing the cases in the courts which pertains to very petty issues. And the employees of the government who will be found to violate this national litigation policy, effective requisitory action would be taken against them. Then fast track courts have been created to look into the issues of which relates to POSCO Act, POSH Act, that is Prevention of Sexual Harassment at Workplace Act, etc. So these are the major steps which the Government of India has taken till now in order to address the issue of judicial pendency. So the first is with regard to appointment of judges. As we witnessed right now that we have low judge to population ratio and there is delay in filling of vacancies. So in this regard, we can go for All India Judicial Services. So this would go a long way in improving the quality of judges at the subordinate court, because majority of the cases are pending in the subordinate courts, and the states would be taking up the people in the subordinate judiciary through this All India Judicial System that would be there. Okay, All India Judicial Services. So the people would be appointed through a national examination. This would go a long way in improving the quality of judges at the subordinate courts, and it would also go a long way in addressing the issue of delay in filling of judicial vacancies. Then we need to promote alternative dispute resolution mechanisms so that dispute could be settled outside the courts itself. We need to make people aware of the different alternative dispute resolution mechanisms that are there, and the government also need to take requisite measures so that ADR centers could be created and the requisite educational facilities could be put in place so that we get the skilled professionals in this regard, that is arbitrators, conciliator, mediators, etc. Then the government needs to strengthen the judicial infrastructure, especially in this regard, the government needs to increase the amount of allocation as a percentage of GDP which it is spending on judicial infrastructure. Then we need to reform the criminal justice system. In this regard, we need to make sure that the investigation wing and the wing which would be looking into law and order should be separated, and the police forces needs to be adequately trained with regard to forensics technology so that the criminal justice system could be reformed. And when it comes to grievance redressal, the government could set up internal grievance redressal in order to settle the disputes between the different government departments and their employees, so that we could reduce the cases wherein the government is the litigant. Okay, because one of the major issue is the government is the largest litigant when it comes to the number of pending cases which are there. That is all that we have to make note of from this very topic. Let's move to the next one. Let's look into our second topic, which pertains to constitutional morality. And this topic relates to this very aspect of your GS paper 2 syllabus. We also have a previous year question in this regard. So after listening to this very discussion, please try and attempt this very question. Now what is the context? So the writer in this very editorial has pointed out that in the recent Supriya Chakravarti versus Union of India case, that is marriage equality case, the Supreme Court ended up privileging the majoritarian morality over constitutional morality. This case wherein the Supreme Court denied legalization of same-sex marriages. Now in this regard, what we need to understand is, what is constitutional morality? Let me tell you first thing, this word is nowhere explicitly mentioned in the Indian Constitution. And that is the reason you do not find exact definition of this very term. But what this term implies is that we need to strongly adhere to the core principles of the constitutions that are there. This term was first given by George Grote, and according to him, constitutional morality places an moral obligation on both the citizens as well as state. What are those moral obligations? When it comes to citizens, they have to adhere to the core principles of the constitution and they have to respect the constitutional state authorities. Whereas when it comes to state, the moral obligation on the state is that it has to operate within the constitutional limits. And when it comes to citizens, the constitutional morality also implies that we have the power to criticize the state when we found out that the state is violating the constitutional limitations. Now, let's look into the sources of constitutional morality. So, the sources are basically a preamble which outline the core, values of the constitution like liberty, equality, fraternity, etc. Then we have fundamental rights which highlight rule of law. Then we have directive principles of state policy which highlight the welfare state aspect. And we have Constitutional Assembly debates, wherein for the first time Dr. B.R. Ambedkar made reference to this very term constitutional morality. He stated that constitutional morality would become a means to address the existing inequalities which are there in the Indian society. Now, as we discussed right now, that when it comes to constitutional morality, this term is nowhere been defined in the Indian Constitution. This term we get to know on account of judicial interpretations. Let's look into the various case laws wherein the judiciary had made reference to this very term constitutional morality. Now, the first time this term was used in Nas Foundation versus Government of NCT of Delhi, wherein the Delhi High Court was looking into the aspect of criminalization of homosexuality, wherein the Delhi High Court decriminalized homosexuality. It struck down Section 377 of Indian Penal Code. In this landmark judgment, the court pointed out that the judiciary should be guided by constitutional morality and not by popular or societal morality. In this landmark judgment, the court pointed out that constitutional morality is something which goes against popular or social morality. And it also pointed out that constitutional morality basically implies analyzing or interpreting the constitution, being guided by the soul, the conscience and the spirit of the constitution. And when it comes to constitutional morality, by using this term, the court nullifies the ordinary legislation which could weaken the sanctity of basic structure doctrine. Then, in Navtej Singh Zohar versus Union of India case, finally the Supreme Court struck down Section 377 of Indian Penal Code. It decriminalized homosexuality. In this landmark judgment, the Supreme Court pointed out that the judiciary should be guided by constitutional morality, and here the core constitutional principle was justice. Then in Joseph Sain versus Union of India case, Supreme Court struck down Section 497 of Indian Penal Code, which basically dealt with adultery, wherein if a married woman and a man enter into sexual relationship, then it was the man who was given the punishment on account of this very section, but the woman was not given any punishment. In this judgment, the Supreme Court pointed out that the adultery basically implies that woman is a property of her husband. So, the Supreme Court, guided by the core constitutional principle of gender equality, struck down Section 497 of Indian Penal Code. Then, in Government of National Capital Territory of Delhi versus Union of India case, the Supreme Court made a request to all the high functionaries of the state that you please adhere to constitutional morality. And if the state adhere to constitutional morality, they are not allowed to exercise arbitrary power. As I told you, when it comes to the definition of constitutional morality, one aspect is the state has to function within the constitutional limits. And in this landmark judgment, the Supreme Court equated constitutional morality to be the second basic structure doctrine, because constitutional morality implies that the state has to work within the constitutional limits. Then, in Indian Young Lawyers Association versus State of Kerala 2018, judgment, which you popularly know as Sabrimala judgment, the Supreme Court pointed out that the practice of prohibiting the entry of women who are of menstruating age to offer prayers in the Sabrimala temple goes against the core constitutional values of equality, justice, liberty, and fraternity. And in this very judgment, the Supreme Court also pointed out that the word morality, which we find mentioned under Article 25 and 26 of the Indian Constitution, basically refers to constitutional morality and does not refers to public or popular or societal morality. Okay. Now, let's look into the significance of this very term constitutional morality. It enables us to uphold rule of law. Why? Because as we discussed in the definition of constitutional morality, it places moral obligation on both the citizens as well as the states. So, both the citizens and the state have to bow down before the core principles of the constitution, and the citizens have to give respect to the constitutional state authorities, and the state has to function within the constitutional limits. And if the citizens found out that the state is violating the constitutional limits, then the citizens can criticize the government. So, it gives an incentive to the citizens that they actively participate in the political processes and thereby enabling upholding of rule of law. Then it preserves the trust of the people in democratic institutions. Why? Because the state is supposed to function within the constitutional limits, and if the state is doing so, the people would be having trust in the democratic institutions. Then it brings positive transformation in persisting social morality, like what we have witnessed. As the Supreme Court, by making use of this very term constitutional morality, has decriminalized homosexuality, has done away with adultery. This is leading to a positive transformation in the persisting social morality. Now, since the Supreme Court has decriminalized homosexuality, we have come far to a stage wherein we are discussing the issue of legalization of same-sex marriages. Okay. Previously, if you see the Indian society, we were not even ready to accept homosexuality. So, it enables us to bring positive transformation in the persisting social morality. Then it strives to create a more inclusive society. What we have looked into right now on account of various judgment, what the Supreme Court is trying to create, it is trying to create an inclusive society for the LGBTQ plus community, for the women, as it has done by doing away with adultery, as it has allowed the entry of menstruating women in the Sabrimala temple. Through these judgments, the Supreme Court is trying to create a more inclusive society. And lastly, it is similar to basic structure doctrine, because as we discussed, when it comes to constitutional morality, it implies that the government or the state has to work within the constitutional limits. So, it cannot exercise arbitrary power. And ultimately, it enables us to uphold the idea of constitutionalism, which basically implies limited government. And how it is similar to basic structure doctrine, as we have discussed right now, in Government of NCT of Delhi versus Union of India case, the Supreme Court equated constitutional morality to be the second basic structure doctrine. When it comes to basic structure doctrine, it is used by the judiciary to struck down constitutional amendments, okay, which goes against the fundamental spirit of the constitution. And when it comes to constitutional morality, by making use of this term, the Supreme Court or the courts struck down ordinary legislation to avoid weakening of the sanctity of basic structure doctrine. Now, let's look into the issues which are there with regard to this very term. There is no explicit mention of this term in the constitution. This is something that we have discussed in the first instance. Now, what is the issue on account of this? Since there is no explicit mention in the constitution, now this term is subjected to subjective interpretation of the respective judges. For example, in Sabrimala judgment, what happened? The majority judges, stated that prohibiting entry of women who are of menstruating age in the Sabrimala temple goes against the constitutional morality. It goes against the four constitutional principles, that is equality, liberty, fraternity and justice. But one dissenting opinion pointed out that constitutional morality also implies that the individual should have right when it comes to the matters pertaining to faith, and nobody has the right to interfere in that. This highlights that this term is subjected to subjective interpretations by the respective judges. Then it hinders organic development of liberalism in the society, because in this the court is adopting a top-down approach, because this demand is not coming from the people, basically the majority section. And this is one of the reasons that if you look at the Sabrimala judgment, we have yet not been able to effectively implement that verdict of the Supreme Court at the ground level, because the society is not ready to accept that verdict. And when it comes to society, you must have heard this saying that laws cannot bring the requisite change in the society. You need to bring in the requisite change in the mindset of the society in order to bring sustainable change in the society. Then it creates distrust among the public towards the state. Why? Because this constitutional morality is being imposed upon us by the judges, which is not an elected organ of the state. On account of this, a distrust is generated among the public towards the legislature as well as executive. And the Attorney General of India has pointed out that it promotes judicial overreach. How? Because the judiciary gets the power under Article 142 of the Indian Constitution to pass orders in order to do complete justice. And by making use of this idea of constitutional morality, the judiciary is basically performing those functions which are to be performed by the legislature and by the executive. So, by that logic, it is violating the separation of power principle. Okay? And this is the reason, as you can see right now, when it comes to the issue of legalization of same-sex marriage, the judiciary has now left this thing to be decided by the legislatures. But previously, by making use of this very term, it has, performed those functions which were to be performed by the legislatures and the executive. Now, the last thing that we need to understand is what needs to be done then. First and foremost, we need to come up with a holistic definition of this very term. So, we need to set up a yardstick in this regard, standardized definition of constitutional morality, so that it is not subjected to the subjective interpretation of an individual judge. Then we need to, apply this term in a balanced way. So this term should be invoked wherein we need to define the constitutional limits of the state. And lastly, we need to make the citizens aware with regard to their rights and duties, so that citizens, actively participate in the political process and enable us to uphold the rule of law. That is all that we have to make note of from this very topic. Let's move to the next one. Now, this next topic relates to South China Sea dispute, and this topic pertains to this very aspect of your prelim syllabus. What is the context? So, the context is China and Philippines traded acquisitions over a collision, as there was a collision between the Chinese vessel and the Philippines ship in the disputed waters in South China Sea, as the Chinese vessels blocked the Philippines boats which were on a resupply mission to Filipino troops, which are stationed in the South China Sea itself. Now, in this regard, the first thing that we need to understand is what is the South China dispute all about. When it comes to South China, it is basically just lying south of the Chinese mainland, and this region is surrounded by countries like Vietnam, Taiwan, Malaysia, Indonesia, Brunei, Philippines, etc. Now, the question that arises is why China is so much interested in this very dispute, in this very region? Because it is a strategically important maritime region. And when it comes to the islands which are there in the South China Sea, different countries are claiming their territorial rights over these very islands. When it comes to Parcel Island, it is claimed by China, Taiwan, Vietnam. When it comes to Spratly Islands, there is claim from China, Taiwan, Malaysia, Vietnam, Brunei and Philippines. When it comes to Scarborough Shoal, it is claimed by Philippines, China and Taiwan. When it comes to the South China Sea, over 90% of the area is claimed by China itself. And it is also, preventing other nations from carrying out military and economic operations in this very region, arguing that this region falls in the exclusive economic zone of China. What is exclusive economic zone? So it basically extends up to 200 nautical miles from the baseline. So baseline is basically the low water mark near the coast, okay, from where it is measured. So when it comes to exclusive economic zone, a coastal state gets the right to produce, let's say, hydroelectric power, wind energy, and it also gets the right to exploit, to explore and to take requisite measures for the conservation of the natural resources, okay. But if a particular region is following in your exclusive economic zone, this does not gives you the right to prevent right to navigation of another countries. But then also China is claiming that this whole region is following under its exclusive economic zone. And since the claims of the China are, contested by other nations as well, so what China is doing in this response? So it is, increasing the size of its original islands, and it is also creating artificial islands in order to increase the exclusive economic zone region. Then, another aspect that we need to understand is what is the importance of this very region. So, according to United States Energy Information Agency, according to its estimate, this region has around 11 billion barrels of oil and 190 trillion cubic feet of natural gas. This is an important fishing ground as well, and according to United Nations Conference on Trade and Development, over 21% of the global trade passes through this very region in 2016. So this region is important from the point of view of oil, natural gases, fishing resources, as well as from the point of view of global trade as well. This is the major reason why China is more interested in this very region, because it wants to emerge as a major superpower in this very region. Then what is this 9 dash line? This green line that you are witnessing here, this basically, is used by the China to demarcate the regions over which it is claiming that it has territorial, claims over this region. And this 9 dash line basically extends to around 2000 kilometers from the Chinese mainland. So this 9 dash line is used by the China to demarcate its territorial claims in the South China Sea region. And why it is claiming these islands? It made an argument that historically it has close tied with partial islands, partly islands, etc., as these islands were part of China itself. But these claims of China have been refuted by the other countries. Previously, in 2016, Philippines took China to an international tribunal with regard to territorial claims over Scarborough Shoal. And the international tribunal basically declared that this 9 dash line is not acceptable. But the China did not accept the decision given by the international tribunal in that regard. Okay. Now the last thing that we need to understand is what can be done, how this dispute can be resolved. So various experts have pointed out that ASEAN, which is a grouping of 10 members, can come up with an effective solution in order to address this dispute that we are witnessing in South China Sea region. That is all that we have to make note of from this very topic. Let's move to the next one. Now this next topic pertains to global wealth tax, and this topic relates to this very aspect of your prelim syllabus. What is the context? So the context is European Union in its report calls for 2% global minimum wealth tax on billionaires in order to curb tax evasion. Why the European Union is making this argument? It has pointed out that when you look at the tax rate, the billionaires are merely facing 0 to 0.5% of effective tax rate when it comes to their wealth. Whereas when it comes to their wealth, it has grown exponentially by 7% on an average from 1995 annually. So in this background, the European Union is making a call that we need to impose 2% global minimum wealth tax on the billionaires. Now in this regard, we need to understand what is wealth tax. So wealth tax is a kind of direct tax which is imposed on the assets which are owned by an individual. Does not matter whether that asset is generating income or not. And this wealth tax is basically based on the market value of that very asset. And when it comes to wealth tax, it can take the form of inheritance tax, property tax, etc. or gift tax. So the European Union has made this demand that in the background of tax evasion, we need to come up with a global minimum wealth tax which would be amounting to around 2%. Now, in this regard, the European Union has pointed out that we have been able to tackle the offshore tax evasion on account of automatic sharing of bank information. But despite this mechanism in place, offshore tax evasion is still continuing. Why? Because when it comes to the financial institutions, they are reluctant to share the financial details of their customers, otherwise their customer would not be putting the money in those financial institutions. And even when it comes to financial institution, if they do not comply with automatic sharing of bank information, they are not subjected to any penalties. Second reason, as was pointed out by the European Union in its report, is that what we are witnessing when it comes to billionaires, they are shifting their money and they are investing in real estates because these assets are not well taxed. So that is why the European Union is floating this idea of global minimum wealth tax. Now in this regard, we need to understand what is tax evasion. Tax evasion basically is an illegal practice which you use in order to reduce your tax liability. What you actually do in this, you either inflate your expenses and you underreport your income. So you basically underreport the profits in order to reduce your tax liability. How we do this? What are the methods? So what the corporates do, they showcase their personal expenses as business expenses, or they would not give the requisitory documents to the tax authorities through which it could be assessed that okay, what was their actual income or actual profit in that very year. So these illegal practices, fraudulent practices that we use in order to reduce your tax liability is referred to as tax evasion, and remember, this is an illegal practice. Then in its very report, the European Union also made reference of global minimum tax, which was initially floated by OECD, and it was put in place in 2012 as 140 countries signed this framework. Under this, 15% effective tax rate would be placed on corporate profits with regard to multinational corporations which are having an annual global revenue of over 750 million euros. So this was done in order to address the issue of base erosion and profit shifting, and in order to address the race to bottom. What is this? Now what used to happen? In order to attract the foreign investment, the different countries used to reduce the tax rate. Okay, there is a competitive environment where every country is reducing the tax rates so that they could attract the MNCs and the foreign investment. This is what is referred to as race to bottom. On account of this, what was happening? The MNCs do not have to pay adequate taxes on the profits that they are generating, and what they used to do is the MNCs or the foreign companies used to engage in base erosion and profit shifting. This is a tax avoidance, mechanism, wherein the foreign companies used to artificially shift their profits to low or no tax zones, so that they have to pay less taxes. So when it comes to base erosion and profit shifting, what the foreign companies used to do, they used to make use of the loopholes or the mismatches when it comes to the tax rules in different nations. So they used to artificially shift their profits to lower no tax zones so that they have to pay less taxes. So this global minimum tax intend to address this very issue. How? Let's suppose there are two countries, A and B. Now, going by race to bottom, the A country is having a tax rate of 5% only because it wants to attract foreign companies. Now, the B country, which is the home country, it is seeing that, okay, A is, levying only 5% of the tax. So, it would be levying the remaining 10% of the tax on the corporate profits of MNCs, so that in total, the MNC has to pay around 15% tax. Okay, this is what is global minimum tax. But in the European Union report, it pointed out that even though we came up with global minimum tax, what we are witnessing is the MNCs are able to avoid this much amount of global minimum tax by engaging in greenwashing. By stating that they are engaging in such activities or such projects which are helping them in reducing the carbon dioxide emissions. And they are earning carbon credits in return of that. Now, what is greenwashing? So, it is an unjustified claim which a company makes to highlight that their product or their service is more environment friendly. But actuality, that is not so. You will be able to understand this with the help of very example. Volkswagen admitted to cheating emission test. What it has done, it has fitted various vehicles with a defect device. What it used to do, it has a software that could detect when it was undergoing an emission test, and it would alter the performance to reduce the emissions level. The company was touting the low emissions and eco-friendly features of its vehicle in the marketing campaign. So it was making a claim that we have designed such a vehicle which is more environment friendly. But in reality, that was not the case. But in actuality, what we figured out that these engines were emitting 40 times more nitrogen oxide pollutants as was permitted. So greenwashing basically refers to unjustified claims which are made by the companies that their product or their services are more economic, more environmental friendly. But that is not the case in reality. Now, when it comes to greenwashing, it erodes the customer's trust even in those companies which are actually undertaking such projects which help in reducing the carbon emissions. That is all that we have to make note of from this very topic. Let's move to the last one. Now, this last topic relates to Siachen Glacier, and this topic pertains to this very aspect of your prelim syllabus. We also have a previous year question in this regard. So, after listening to this very discussion, please try and attempt this question. The context is an Agniveer died in line of duty in the Siachen Glacier. So, in this regard, we need to understand the locational aspects with regard to Siachen Glacier. Now, Siachen Glacier, which is this region, is located in eastern Karakoram range in the Himalayas. It is just northeast of the point NJ9842, which is here. Okay, where the line of control between India and Pakistan ends. It lies between Saltoro Ridge immediately to the west and the main Karakoram range to the east. The Saltoro Ridge originates in the north from the Sia Kagri peak on the China border in the Karakoram range. The entire Siachen Glacier with all major passes is currently under the administration of India after 1984 Operation Meghdut. Pakistan controlled the region west to Saltoro Ridge, far away from the glacier. Now let's look into the different geographical locational aspects with regard to Siachen Glacier. Now here we have Saksham Valley, which is this black region. It is basically the territory which has been ceded by Pakistan to China in 1963. And here we have Pakistan occupied Kashmir, Gilgit, Baltistan is there. Here we have Leh, here we have Askai Chin, and here we have Nubra Valley, which is fed by the Siachen Glacier. Now, as the Siachen Glacier melts, it is the main source of Nubra River, as we discussed right now, which drains into Shyok River, and Shyok in turn joins the Indus River. So, thus the glacier is the major source of Indus River. At 76 km long, it is the longest glacier in the Karakoram range and second longest in the world's non-polar areas. What is the significance of this very region? So, the significance is the Siachen Glacier is strategically important for India because it separates Pakistan from China. What we discussed, here we have Saksham Valley, here is Pakistan occupied Kashmir, and here we have Askai Chin. So, this region basically separates Pakistan from China. And it also enables India to monitor Gilgit and Baltistan region of Pakistan. That is all that we have to make note of from today's analyst. Thank you for listening to this very discussion and all the very best for your preparation.